Namaskar. My very distinguished colleagues on the bench of the Supreme Court, Justice A.S. Bopanna, Sister Justice B.V. Nagaratna, with whom I go a long way since we were in college and school in Delhi at the same time. Our fathers were distinguished members of the bench at the same time of the Supreme Court. Justice Rituraj Avasthi, Chief Justice of the High Court, Honorable Judges of the High Court, Honorable Members of the District Judiciary. I prefer to call it the District Judiciary and not the Subordinate Judiciary. All the members of the Karnataka State Judicial Officers Association, including those who are present on the dais, and all of you in the audience. Justice Bopanna called me very aptly the son-in-law of Karnataka, which is really, really true in a way, because my mother-in-law, my father-in-law, and my sisters-in-law settled down in Karnataka, and they have made Karnataka their home. So I'm certainly a son-in-law of Karnataka, at least by naturalization, if not by adoption. I can be called a nephew of Karnataka, because the very noted Kannada playwright Adya Rangacharya, who is known more well known by his pen name of Sriranga, was married to my father's sister, and they lived in Dharwad. And his works in 1950, 1960, 1970, 1980, until he passed away in 1984, they really anticipated the social change which is taking place in our society, the change in gender roles, the advancement of gender, the advancement of marginalized communities. This was foreseen by him 30 years before this took place in our country. His daughter, Shashi Deshpande, who is a highly celebrated English writer, happens to be my first cousin, and her sister, Dr. Usha Desai, who with her husband stays in Mumbai, she is a very distinguished doctor in her 80s. She has now taken it upon herself to translate Sriranga's works from Kannada into English so that they can be spread, the message can be spread to the rest of India. I've spent my childhood years driving from Mumbai, Pune, Kolhapur, Belgaum, and then Dharwad, and then spending vacations with the family in Dharwad. So I have warm memories of those early years of childhood. Now, how do you identify a civil judge? I was told this story by Justice Sarosh Kapadia, who became the Chief Justice of India, and then by Justice R.C. Chavan, who is the Vice Chairperson of the E-Committee. Well, at one time, if you wanted to identify a civil judge, you would always identify a civil judge as a person who you would find with a black coat, a white trouser, a tie, and riding a bicycle. It was a little gender biased because it didn't factor in the few members from the women lawyers or women judges who are coming into the profession, and now there are states where almost the same quantum of women judges as men judges joined the district judiciary. So that was how you identified civil judges in the years gone by. I know as a young child, when my father was a judge of the Supreme Court and Justice Nagaratna's father and he were together on the Supreme Court, Justice Nagaratna's father was a very distinguished scholar, not merely of law but of Sanskrit. And as Chief Justice of India, my father had coined a very special phrase for Justice E.S. Venkatramaya. Fondly, when they met every morning in the Chief Justice's chamber for a cup of coffee, my father would always call to him and say, "Swamiji aiye." So he always called him Swamiji because he was so learned. But how did you identify a Supreme Court at that time? You would see all of them traveling by chair car from Delhi to wherever they lived, whether it was Maharashtra or Bangalore or Chennai or Ernakulam, as Justice K.K. Matthew lived in, or Justice Krishna Iyer. Because the first 400 kilometers in your LTC had to be borne from your own pocket, and the government would give you the rest of the pro rata for the payment of your LTC. They drove their own cars. There was no 200 liters of petrol available. So we used to stay in this place in Mumbai called Malabar Hill, which was in the bottom of the hill. And when we came to the top of the hill, all the three judges who used to carpool with my father would switch off the engine, and then they would tell me, a little child sitting in the back, please push the car so that the petrol will run longer. So these were the times which judges really came up. I think the Shetty Commission changed all that. So also the involvement of the Supreme Court in cases such as Malik Mazhar Sultan. So we are much better off today than what our forebears were, our ancestors in the judiciary who've passed on the baton to us were. Today, how do you identify a civil judge? Today, I dare say, you will not be able to identify a civil judge separately from any other citizen because you merge with so many others who are tech-enabled citizens of India. That is the forward vision of the Indian judiciary. Before I actually present a few thoughts which I have coined for this morning, I must tell you about the performance of the Karnataka state judiciary, the district judiciary, in the recent 2 years. Between 24th March 2020, when the pandemic broke out, and 22nd April 2022, 31,09,888 cases were registered. These statistics I don't get because I am a chairperson of the committee. They are now available on the National Judicial Data Grid, which is a transparent system. We are open to all citizens. 28,76,059 cases were disposed of in the district and taluka courts in Karnataka. So when we talk about the flip side, about what ails the judicial system, we must also remind ourselves what is the strong aspect of our system. That during these years of the pandemic, when 31 lakh cases could be registered, it reflects the citizens' confidence. We were able to dispose of 28.76 lakh cases in the district and taluka courts. Today, 1,184 judicial officers use the Justice mobile app, which has been developed for Karnataka in special, and of course for the rest of the country. Virtual courts for traffic challans are operational in Karnataka. Very interesting little tidbit which I can share with you. We have this process delivery mechanism now which we have prepared in the E-Committee called N-Step. N-Step is nothing but a smartphone gadget which records the service of a process or summons and records the GPS coordinates of the house where the process is being delivered. It is signed by the person who accepts the service. If service cannot be delivered, he takes a photograph which is uploaded onto the central server. So 2,25,000 processes were allocated to bailiffs in Karnataka. 2,09,120 deliveries were attempted, and 1,49,343 processes have been delivered through the N-Step mechanism. This shows the involvement of the Karnataka judiciary in technology involvement. 4,13,925 final orders and judgments of the Karnataka High Court are available on the Judgment Search portal today, which is a free text search portal which has been devised by the National Informatics Center in coordination with the E-Committee. But let's not only pat ourselves on the back. There are other statistics which I must always tell you, because we look at both sides of the picture and then form a view. As on 22nd April 2022, 18.37 lakh cases were pending in the district courts in Karnataka, out of which 8.82 lakhs are civil and 9.55 lakh are criminal cases. 157 cases are pending for more than 30 years, 6 of them criminal and 151 civil cases. The oldest criminal case, CC 648 of 2000, registered on 22/1/1985, is pending before the Principal Judge Neelamangala, Bengaluru, but the reason is that the accused is absconding since it was registered. The oldest civil case is Insolvency Case 2 of 1962, registered on 5th January 1962, which is pending before the Principal Judge and Civil Chief Judicial Magistrate at Belgavi. 1,84,133 criminal cases are pending because the accused is absconding. Now, 8948 cases are pending because trials have been stayed by the High Court. The oldest is of 1978, a petition for final decree 76 of 1978 before the Principal Senior Civil Judge, Bengaluru. So these are some of the statistics which I think are important for us to lay bare when you are going to discuss the impact of technology on the judicial process and what role the district judiciary has to play. I'm delighted to have this opportunity to interact with you this morning, and I'm grateful to the learned Chief Justice for even having invited me. The duty of a judge is well served on a robust foundation of experience, not just of one's own, but of the entire judicial fraternity. These conferences are a key to bolstering institutional development and knowledge. In the words of one of the finest jurists of all times, Oliver Wendell Holmes, the law in its own experience, he says, holds true for the institutions that uphold the law. I could not agree more with this statement. Judging has been my life. As a child, I have seen my father dedicate his life to the law. His impeccable sense of duty and dedication served as a constant inspiration in my journey as a judge of the Bombay High Court, at the Allahabad High Court as the Chief Justice, and now at the Supreme Court. 22 years on the bench has taught me a lot about law and life. One of the most significant takeaways in my judicial experience is the systemic importance of the judiciary at the grassroots level. The hierarchy between courts is a matter of administration and not one of importance. It is the responsibility of every member of the judiciary to foster a space that echoes justice. Courts in the district judiciary are the first doorway to a responsive court system. It is sometimes said that there is a divide between judges who are drawn from the bar and judges who are drawn from the service. In many high courts, the divide is more pronounced than the others. Speaking of myself, I must tell you that some of the greatest experiences of life that I have learned as a judge since 29th of March 2000 are the experiences I have imbibed from judges who came from the district judiciary, whether in my contact with them as a lawyer appearing for the High Court, when I spoke to the Registrar Vigilance or the Registrar Legal, or as a judge when we interacted with our own colleagues who came from the district judiciary, who told us about the problems which the district judiciary faces, the realistic assessment of the conditions in which way they work, what transfers mean to a district judge if those transfers are not made with the highest element of transparency and probity by the high courts. How spouses would be separated in Uttar Pradesh, for instance, where one spouse had to constantly remain in one station while the other spouse would be posted all over, only in the interest of the education of the children. So these lessons of life, without which my training as a judge would be incomplete, I learned from my interaction with the district judiciary in India, in different states. Thus, in my address today, I wish to focus on the most critical cog of our judicial system, the district courts. I will be addressing the infrastructural changes that can be implemented at the district courts and the high courts to achieve substantive and procedural justice. However, before we even speak of procedural or substantive justice, it is imperative that our courts are accessible as institutions. Accessibility, in one sense, is emblematic of justice. The digitization of courts is one way in ensuring greater convenience and reducing costs associated with litigation. The digitized world that we presently inhabit is unimaginable from a few years ago. It has reconfigured our sense of self and community by adding another dimension to our lives, that of digital personhood. It has also transformed our conception of basic services. The Digital India program aims to achieve inclusive growth by transforming India into a digitally empowered society and knowledge economy. The union and the state governments are constantly creating initiatives to improve governance, provide public services, and strengthen accountability mechanism. In this rapidly changing milieu, the judiciary cannot be far behind. Judicial infrastructure has to necessarily adapt to the digital world. The silver lining to the havoc wreaked by the pandemic was that it presented the judiciary with two choices. Either we adapt to a virtual system or aggravate the problem of pendency that plagues our system. In 2004, the Supreme Court of India established the E-Committee to adapt the administrative reforms in the judiciary to the information technology revolution. The main aim of the e-courts project was to provide a transparent, accessible, and cost-effective justice delivery system to all citizens through information and communications technology and internet-enabled courts. Since the pandemic struck, the e-Tal website has recorded over 3.54 billion electronic transactions under the e-courts project. A total of 9.6 million cases were heard by all courts through video conferencing. The e-filing software has been utilized to file over 1,100 cases. Finally, as a testament to the effectiveness to this mode of justice delivery, out of 13 million cases registered in India, 8.3 million cases were disposed of, thus achieving a disposal rate of over 60%. To ensure sustainable progress that is cognizant of the digital divide, the e-Seva Kendras assisted litigants with obtaining soft copies of judicial orders, e-filing of petitions, appending digital signatures, facilitating e-payments, and guiding people on availing free legal services from legal aid authorities. In other words, technology for us is not intended to reach out only to the high-value commercial disputes or make the Indian judiciary responsible to the needs of investment and industry. Technology for us is to reach out to the doorstep of every citizen. And one of our latest initiatives in the E-Committee is to merge the e-courts project and the delivery of e-court services with the common service kendras, the common service centers, so that every village will be entitled to avail of all the e-court services which are provided otherwise in the district judiciary and in the high courts. As a result of the virtual performance of our judiciary and the virtual hearing platforms, I believe the Supreme Court of India became truly a national court. We became a truly national court in a participative sense, not even a sovereign sense. We were always a national court since the day we were established. But we have become a national participatory court, where young lawyers from across the country, be it Bangalore, be it Kerala, be it Tamil Nadu, be it Manipur, Maharashtra, just name the state, Bihar, UP, they address you. They have the safety of their own homes. Young women lawyers are able to come and address cases to the Supreme Court, consistent with their needs of multifarious responsibilities which all women have to perform in our society. So technology does not just change the mode of adjudication, but it also transforms the adjudicatory process itself. Hence, phase 3 of the e-courts project places the e-judiciary at a central part of its vision. If strategically deployed, this can completely transform the citizen's experience for the judicial process. For instance, the traffic courts dealing with ordinary traffic violations have received a substantial boost with the introduction of automated settlement processes, which allow persons to pay their dues without grappling with litigation and without having to deal with touts in our courts. Similarly, several avenues for introducing artificial intelligence in the dispensation of justice are being explored, such as marking defective petitions and projecting case progress. Digitization is actively pursued through the National Judicial Data Grid, with the hope that it eventually helps with smart scheduling of cases, auditing disposal rates of high courts and other courts, and identifying the specific causes of delay. In the first session on application of advanced technology, I invite all of you to expend some thoughts on how this transition can be made in a just and effective manner. Integrating our pre-existing systems with technology is the future of our justice system. The rights of all stakeholders could be well preserved by critical inputs from judicial officers. I must commend all the courts in the state of Karnataka for demonstrating a progressive commitment to the e-courts initiative. Karnataka was one of the first states in the country to use the virtual forum to hear cases on a regular basis. This is a huge step towards the state's target of ensuring zero pendency of cases older than 5 years. The staggering figures on the penetration of e-court services, e-seva kendras, e-filings, and live telecast of High Court proceedings sets Karnataka apart as a pioneer in justice delivery. I implore all of you to continue on this path and deliberate on best practices across our respective courtrooms. I believe that these initiatives will bolster Karnataka's image as a litigant-friendly and cosmopolitan state. Yet, as we are now going to start live streaming your cases, please understand that it changes the role of each one of you, whether you are in the high courts or in the district judiciary. Every judge is the master of her court. She has to deal with all stakeholders of the judicial system, whereas the principal district judge has to run the administration of the entire district. IAS officers are well trained in this area. Likewise, the judicial academies will need to focus on this aspect of personality development. A judge must possess good communication skills. As we go forward with live streaming of cases, of court proceedings, this may help a judge to conduct themselves in a dignified manner in the court. What you say in court now reaches out not merely to the 50 lawyers in your court, but 5 billion people across the world. Inculcating leadership qualities may also help in addressing the issue of trust deficit. In charting our course for judicial reform, there are several areas of concern beyond adopting technology for greater efficiency, and that's the next part of my presentation. In a country as diverse as India, accessibility, inclusiveness, and opportunity are three difficult paradigms to knit together. All social institutions have the responsibility to work towards blending these three qualities into one. Courts can contribute to this aim in a major way. It is imperative that every level of the judicial system is accessible, litigant-friendly, and inclusive to persons from all sections of society. The physical and digital architecture of courts must be inclusive as a matter of conscious design. The step towards e-filing is not only a means for achieving greater convenience and offset the environmental cost of paper, but also to make them accessible for persons with visual disabilities. Instead of printing and scanning their submissions, we have to get to a point where the default position entails lawyers filing PDF documents as they are prepared. The current practice of printing and then scanning documents is a futile and a time-consuming process that does not serve any purpose. We have to devise a practice of using digital signatures or requiring signatures only on the last page of paper books in order to ensure that lawyers do not feel compelled to print and then scan paper books because of the signature requirement. Wherever visual captchas are used to access any information, text-based captchas must also be provided. In transitioning to hybrid systems of hearing, we must ensure the availability and closed captioning and sign language interpreters. Court websites must have clearly labeled buttons and calendars to select dates. They must be accessible. Judgments and orders must be published in an accessible format without improperly placed watermarks. I can't tell you how annoying it is in the Supreme Court when you get High Court judgments which have bold watermarks. You can't read what is written by the judge on the page on which it is printed. So imagine how more difficult it is for a person who has visual disabilities in reading these judgments. We need to begin digitization by digitizing the lowest levels of our judiciary. We are digitizing old cases, but we must now digitize present cases. Otherwise, 5 years down the line, we'll be again left with a backlog of cases which we have to still digitize. Several infrastructural interventions are necessary in our physical courtrooms to make them accessible for marginalized groups. Courtrooms should ensure the presence of ramps and adequate support for persons with disabilities. We must have vulnerable witness courtrooms. Recently, under order which was passed by me, we have appointed a former Chief Justice of the High Court of Jammu and Kashmir, Justice Geeta Mittal, who was looking after this project for the whole country. Microphones and speakers must be installed in courtrooms. Furnishings must be suitable to eliminate the echo effect that disproportionately impacts persons with hearing impairments. The E-Committee is currently working with a dedicated group to receive inputs on specific interventions that can be made to make the judicial ecosystem accessible. It would be beneficial for the cause of justice at large if these efforts are integrated across all high courts and district courts. As women interact with the judiciary as lawyers and litigants, we must be mindful of the architecture of our physical spaces that are designed to exclusively cater to men. When I was an administrative judge for Kolhapur years ago, we realized that there was no bathroom for women. So the young judicial officers came and told me that we use the toilet when we leave home early morning, and our next interface with the toilet is when we go home late in the evening. That was the state. And I'm not talking of 50 years ago, just 10 years ago. So as administrative heads of our respective courtrooms, it is all of our responsibility to ensure that courts provide separate washrooms for women, disabled persons, and transgender persons, functioning creches, child care spaces, and waiting rooms for pregnant and elderly persons are welcome initiatives for creating a truly inclusive space. People from marginalized communities like Dalits, women, LGBTQ persons may lack adequate access to secure their rights and entitlements, including avenues to obtain legal recourse. Women are mostly kept out of family matters such as land and company deals. Being disowned by family members, transgender persons also face this barrier. This can be remedied by gearing our legal aid institutions to be cognizant of the specific needs of these communities. The Tamil Nadu Judicial Academy recently sought to create awareness of harmful stereotypes and biases against LGBTQ persons that courts and judicial office orders may consciously and unconsciously perpetuate. While these might seem like small steps in the mammoth exercise of judging, they go a long way in restoring the faith of people in its justice system as a median for change. As judicial officers, we must be cognizant of the gaps in our perception of reality and that of marginalized groups about us. When litigants from the LGBTQ community plead their cases before us, we must be conscious to avoid issues of misgendering them, not using their preferred pronouns or chosen names, or using derogatory language that is rooted in harmful stereotypes. In instances of sexual harassment, the process is often the punishment for the complainant. In conducting criminal trials, the judge must step in to correct the iniquities in society and provide a safe space for women and children to testify. A code to address sexual harassment in courts must also be formulated and adequately publicized. Notably, the Karnataka High Court is one of the first in seeking separate hostels and accommodations for transgenders in higher educational institutions. Courts in Karnataka have also sought to bring about several progressive changes by guaranteeing the access of welfare schemes to LGBTQ persons who are otherwise exclusive from the heteronormative mold. Conscious steps towards inclusiveness and accessibility paves the way for new opportunities, not just for the stakeholders, but also for the judiciary to effect change in society. In discussing digitization and reforms, I would be remiss if I did not share a few thoughts on one of the most potent criticisms that have been leveled against the judiciary, its track record in upholding constitutional principles of liberty. The importance of the freedom of personal liberty under Article 21 has been underscored by the judiciary ad nauseum. However, the true import of these words can only be discerned in practice. The oft-cited rule, bail, not jail, is one of the most fundamental rules of the criminal justice system. Yet, in practice, the number of under-trials languishing in the prisons in India reflects a paradoxical situation, where the provisions for bail meant to preserve personal liberty have been manipulated to deny a person's release. India's National Crime Records Bureau report published in 2020 shows that the number of under-trials languishing in Indian prisons is greater than the number of convicts. Out of a total of 4.66 lakhs prisoners, about 3.24 lakh prisoners are under trials. About 71.2% of prisoners
have been confined for periods up to 1 year. 14.6% under trial prisoners have been confined for up to 1 to 2 years. 7.9% for up to 2 to 3 years, and 6.45% of over 3 years. Criminological studies demonstrate that an accused's marginalization and deprivation in society is compounded manifold when it intersects with the realities of the criminal justice system. A demographic survey of Indian under trial evinces that marginalized sections of the society are incarcerated in disproportionate numbers. About 69.4% of the under trials are either illiterate or have been educated only up to class 10. The scheduled castes are overrepresented and account for over 21% of the under trials when they make up only 16.6% of India's general population. Similarly, the scheduled tribes make up for 10.5% of the under trials, while they account for 8.6% of the population. Muslims constitute 18.7% of the under trials, while their share in the population is 14.2%. Other religious minorities constitute 7% of the under trials. About 1,212 women under trials are accompanied by 1,049 children in our jails. The judiciary's commitment to the constitutional promise of personal liberty has to be bolstered in two significant ways. First, by addressing the quantitative delay in disposing of criminal matters, particularly bail petitions. And second, improving the quality of justice that is dispensed with by courts. On the first factor of delay, the number of bail applications pending before the high courts is 1,14,835 and a staggering 1,90,703 before the district courts. In 2020, a study found that the average time taken for the disposal of bail matters was determined at 10.321 days. Yet, the average pendency of bail matters was found to be 4,668 days. These shocking figures demonstrate the farcical reality to Lord Denning's imploration to the judiciary to give the utmost priority to cases concerning liberty, especially when the law presumes their innocence. While these figures may seem like simple numbers, these are valuable days lost in the life of a person. Deprivation of liberty for even a single day is a day too many. Judges would do well to remember that the authority of the judiciary is associated not with the prestige of the office we hold, but the quality of the justice we dispense. What good is our authority if we cannot apply the nuances of the law to give justice to the deserving? What is the value of the rich jurisprudence developed by the Supreme Court since the independence of our nation to preserve and protect the liberty of each individual if that does not come to the aid of the individual at the grassroots level? And what value is our rich jurisprudence if the jurisprudence only subserves the cause of the rich? Often, judicial decisions on personal liberty are a result of a template-based approach, where judges simply glance over the offenses involved in the case and then render their decision on bail. This has resulted in judges simply reproducing case law without interpreting or analyzing the legal provisions or the facts of the case. Not only is this process against the very tenets of decision-making, but it also violates the trust and faith that is reposed by the individuals of our country in the judiciary. There is also a brooding sense of fear among courts of the first instance on how the grant of anticipatory bail or bail will be perceived at higher levels. There is a trust deficit today. Trust deficit about the district judiciary in the high courts, as a result of which elementary cases where bail should be granted by the district courts, bail is never granted and those matters land up in the high courts. Cases where bail should be granted by the high courts, which don't get disposed of in the high court, or get denied in the high courts and land up in our lap in the Supreme Court. There is this grave distrust, this culture of distrust which we must end. And my sincere request to all the members of the Karnataka District Judiciary is, please do your duties with a sense which rises above this fear about granting bail and anticipatory bail in deserving cases. This results either in rejection of bail or grant of bail on extremely onerous conditions, both of which are undesirable outcomes. In the words of Justice Krishna Iyer, the best guarantee of presence in court is the reach of the law, not the money tag. This practice at the district courts sets in motion a vicious cycle where litigants are trapped in a judicial whirlpool, moving to the higher courts and navigating layers of bureaucracy, touts, delay, and corruption. This affects the poorest of our country the most, who not only suffer at the hands of the police, but also caught in this judicial web without adequate economic resources or knowledge to cut through the red tapeism. We've been confronted in the Supreme Court of criminal appeals pending for 15 years where bail has been denied. 302 convicts who are in jail for 20 years with the appeal still pending in the High Court and still no bail having been granted. We must realize that the values that have been placed in the care of the judiciary, specifically at the district level, chart the course of a litigant's life for months, if not years to come. The access to the district judiciary for the grant of bail should not just become a mechanical process where you take an order of rejection only to go to a higher court. We must have actual justice being delivered by the district judiciary as well. Only this realization would help to rid ourselves of the colonial mindset of referring and treating the district courts as the subordinate judiciary in the hierarchy and in practice. I implore all of you to instrumentalize the ICT tools on NJDG to monitor the pendency and disposal of cases, especially in matters of personal liberty. Issues of personal liberty must be adjudicated with a fierce sense of urgency. So much as we discuss technology today, please also discuss what you need to do to bolster your efforts to ensure that we truly protect personal liberty beyond merely the text of the Indian Constitution. In conclusion, let me tell you about Harper Lee's book, To Kill a Mockingbird, which was an awakening on discrimination's impact on the criminal justice system. It exposed societal fissures that often reflect in the tyranny of the law. Atticus Finch, the dynamic defense lawyer, was representing an African-American man who was falsely accused of rape and condemned, even before he was subjected to a fair trial. As Atticus wrestled with the society and biases of the jury, he expressed a profound hope in the judiciary. He said, "But there is one way in this country in which all men are created equal. There is one human institution that makes a pauper the equal of a Rockefeller, the stupid man the equal of an Einstein, and the ignorant man the equal of any college president. That institution, gentlemen, is a court." He said it can be the Supreme Court of the United States or the humblest Justice of Peace court in the land, or this honorable court which you serve. Our courts have their faults, as does any human institution. But in this country, our courts are the greatest levelers. And in our court, all persons are created equal. These haunting words are an expression of the immense responsibility that a judge dons along with their robes. Callousness with the liberty of the poor or the ideologically dissident is an abdication of the highest purpose that our job will serve. As a judge of the Supreme Court, I hear close to 60 cases every day, which are a combination of civil and criminal and commercial and constitutional cases. Those are the few individuals with the economic wherewithal to move the apex court. Effective justice from a litigant's perspective is realized at the preliminary stages of the judiciary, as opposed to one who has navigated the tribulations of the system and received a relief at the final stage of the judicial process. It is our collective task to strengthen the roots of our judicial system. I'm confident that the sessions over the next 2 days and the strong sense of purpose of the Karnataka State Judicial Officers Association will create a permanent platform to achieve this aim.
I thank you very deeply from the bottom of my heart for all the lovely mementos and the shawl and the accolades which I have received this morning. Since last evening, I have received quite a few garlands from the High Court and from the members of the district judiciary. I was just thinking, I turned 60 2 years ago in the pandemic. Ordinarily, at least in Maharashtra, I'm sure the same in Karnataka as well, when you turn 60, you exchange garlands once again. So I was just thinking to myself, and all these beautiful garlands were given to me. I said, I wish Kalpana was with me on the stage. We could have perhaps made up for the lost ground of the last 2 years when the pandemic denied me the joy of exchanging garlands with my lovely spouse, who is also with me, thanks to the invitation of the High Court. Thank you very much.
Well, ladies and gentlemen, you would all agree with me that was indeed a highly visionary, thought-provoking, and of course, inspiring inaugural address. So